Welcome once again to Lehto's Law. Here's Steve Lehto.
We've talked a bit about drones lately, and there's a lot of confusion in the area because they're governed by the FAA, but they're also very, very inexpensive, and a lot of people get them. They're fun to play with, and so people shoot videos and they post them on YouTube, then they get in trouble because the FAA says, hey, that's a commercial purpose you're putting that drone to. But one other use for drones is law enforcement. And this is an interesting case out of Michigan, by the way. Brian sent it to me. Township violated Michigan couple's privacy by using drone. The court says you need a warrant to use a drone in some situations. They didn't get a warrant. So this is a great case. Beth LeBlanc wrote it for the Detroit News. A Michigan Court of Appeals panel ruled that a northern Michigan township could not use drone photos it obtained without a search warrant to prove a resident wasn't complying with zoning rules. So the panel ruled 2-1 that the use of a drone to photograph the backyard of the couple violated their reasonable expectation of privacy. And Long Lake Township, which is the municipality, must obtain a search warrant if it wants to take photos using a drone over their property. Now, novel ways to conduct surveillance do not diminish a person's reasonable expectation of privacy, wrote Court of Appeals Judge Kathleen Jensen in the decision released this past week. Any reasonable person would have expected a low-altitude drone overflight to be trespassory, which is a variation of the word trespass, and exceptional, whether the drone flew as high as a football field length or flew directly up to an open bathroom window. That's what she wrote. She is joined by another judge, so like I said, it was a 2-1 decision. The couple filed suit against the township in Grand Traverse County Circuit Court in 2018, arguing that photos the township had taken of their property with a drone should be thrown out of court because they were an invasion of privacy and a violation of the Fourth Amendment, which protects people from unreasonable searches and seizures. And now remember, the Constitution does allow the government to get some information by using a warrant. But without a warrant, without a search warrant, then what they can do is severely limited. The couple also argued the drone operator had violated Federal Aviation Administration guidelines when he flew the drone over their property. And so here's the thing. Law enforcement also has to follow the rules when it comes to the FAA. The township referred to prior cases that ruled that photos from a manned aircraft were legal to support its actions. The township took the photos to show there was a significant increase in the amount of junk being stored at the property, violating the zoning ordinance banning illegal salvage or junkyards. And here's the question. If you can't see it without flying over it with a drone, how big of an eyesore could it possibly be? That's one question you have to ask. The drone operator, according to the township, had a constant visual line of sight on the drone and had kept it below 400 feet of altitude in compliance with FAA regulations. So they're claiming that their guy kept within the FAA regulations. Of course, he also kept it below 400 feet. So remember that the court was saying, we're not buying the argument the township's making. The township has said, well, look, the Supreme Court said that an airplane can fly over your property legally. Happens all the time. Go out in your backyard and watch, and eventually an airplane's going to fly overhead. Just trust me. So airplanes flying overhead, for them to look down and see something, well, they're flying overhead. That's what they do. But the difference is a drone flying beneath 400 feet, which is going to be some number between 0 and 400, is getting closer to your land than the airplane flying overhead, assuming that they're following the rules up there, okay? And also, an airplane flying overhead is not hovering and loitering, as we say, over your property. I hope not. But the airplane that flies overhead is brief. The drone loitering below 400 feet is intrusive. Grand Traverse Trial Court denied the couple's motion when they requested to suppress the images, finding that defendants did not have a reasonable expectation to privacy in their own yard. The appeals panel reversed that decision, noting that drones were intrinsically more targeted in nature than airplanes, the use of which to take photos has been upheld by other courts. So courts have said, yeah, airplanes, yes, but the drones, not so clear yet. So the legislature also has ruled drones should not be used to violate privacy or to perform an act that would be illegal if performed by the operator in person. So they're basically saying, look, you have to consider that drone to be an extension of the operator, okay? So if it was illegal for me to go up 10 feet above your property, 20 feet above your property, and spy, then a drone is not allowed to do that. The court also noted that the township could have easily obtained a search warrant to take the photos with the evidence it said it already had, because they claimed that they had unrelated site inspection photographs and complaints from defendants' neighbors. So this is one of the things that we often forget. When someone comes into court and says that should be thrown out because it was obtained through a warrantless search. And people say, that's not fair, you're throwing out perfectly good evidence. Well, no, what wasn't fair was that they could have easily gone to a judge and said, look, we got complaints from neighbors, we got photographs that we already got somehow legally, we believe and have, good faith basis to say that this is a problem. We want a warrant to conduct a drone survey. And in that case, it would be supervised by a judge who'd write out the warrant, or who would sign the warrant after it had been written out properly. And the judge could say, for instance, how high is the drone going to be? How long is it going to hover over their property? And I doubt that the judge would say, oh, go in and hover at 5 feet for 6 hours. It's more likely going to say, how long is it going to take you to get these photographs? Okay, make it brief. But that's if the warrant got signed. But they didn't even bother trying to get a warrant here. So the judge wrote, if a governmental entity has any kind of non-trivial and objective reason to believe there would be value in flying a drone over a person's property, as they did here, then we trust the entity will probably be able to persuade a court to grant a warrant or equivalent permission to conduct a search. Now, a judge did dissent. A judge dissented. And that judge said she was also concerned about the intrusive nature of drones, but felt the court was bound by precedent, allowing for the use of manned aircraft to take surveillance photos. And this is a great example where people often ask me, how is it possible that if courts follow precedent, they seem to be confused an awful lot? Can't they just find a previous case? Well, there are no previous cases exactly on point where it was a warrantless search by a drone over property. And so everyone kept pointing out to the cases that said you can fly an airplane over property. And so then the question is a drone like an airplane? Well, in some respects, yeah. It flies by magic. Somehow it doesn't fall out of the sky, okay? But there's ways they're not alike. And I've already addressed all of them, primarily because the airplane flying overhead, number one, you're aware of it if you're outside and you look up because they make more noise and they're larger. But number two, it's also brief because they tend to fly over and keep going. Now, if an airplane was going to do surveillance of this property, it might fly back and forth a couple times, but it's going to be at a much, much higher altitude. And that's clearly a distinction between a drone and an airplane. So the drone is smaller, it's sneakier. Now, I understand you can hear drones. I've seen drones in the wild. I know you can hear them. But I don't know how big this piece of property was. But also the fact that the drone can loiter and can hover around and buzz around things and could hide behind a tree, for instance. I mean, there's all kinds of things that the drone can do that an airplane cannot do. So to say, well, there's already been a ruling on airplanes, therefore drones, no, drones and airplanes aren't the same thing. So this is an example of a judge who I think doesn't like the outcome and is blaming it on, I think there's already precedent on this because we've got, airplane law. The U.S. Supreme Court has ruled that things visible from a public navigable airspace are not protected by the Fourth Amendment, that judge argues. And she wrote, she wasn't confident the distinction between a manned and unmanned aircraft would carry so much weight. While I too have concerns about the potentially intrusive nature of drones, I would not categorically conclude that the use of drones without a warrant violates the Fourth Amendment, where one is used to view what is otherwise plainly visible to the naked eye from airspace navigable by the public. And there she's missing one of the biggest distinctions, and that is that the drone operator, according to Township, kept the drone below 400 feet. And I'm pretty certain that airplanes flying overhead are not going to be flying that close to the ground. They might legally be allowed to, but I'm saying that generally speaking, there's a difference. And that is drones operate down here, airplanes operate up here, this being a hypothetical representation, not to scale, of the outside world, okay? So there is a big distinction between a drone and an airplane. And I guess the question is, what would that judge say if they'd done it by helicopter? So a guy comes in with a helicopter and he's got a spotter in the helicopter with a camera, okay? Comes in with a helicopter at 100 feet, hovers around the property, photographing it, 100 feet high, and then later flies off, okay? Navigable airspace in a helicopter, you got a problem with that? That's just like an airplane. Helicopters are like airplanes. So, point is, right now, Court of Appeals in Michigan, and again, this could be appealed higher, and if it is, we'll see. But as of right now, it appears, at least in the state of Michigan, to go over a person's property with a drone and get photographs for a criminal investigation, you would require a warrant to do that. And a warrantless doing of that will make it so that information gained from that flight would be inadmissible in court as a violation of the Fourth Amendment, which I agree with wholeheartedly. So those of you who are drone operators around the country, I suppose you should think about this, but this affects more the people who are being droned. But it's also good just to know what the law is in an emerging field. So if you're a drone operator, I'm sure you'll find this interesting as I did. So again, this is Michigan only right now. And so the other 49 states, I don't know if any other states have ruled on this particular issue or not. If anybody's seen such a case, please send it my way. I'd love to see it. If I get some, I'll put them in the comments below or the description of the video. But as of right now, the Michigan Court of Appeals has ruled that to use a drone to photograph someone's property without their permission would require a warrant for those photographs to be admissible in court. Township violated Michigan couple's privacy by using drone, court says. Beth LeBlanc wrote it. Brian sent it. Great article. Questions or comments, put them below. I'll just talk to you later. Bye-bye.
Thank you for watching Lehto's Law. A committee is a group that keeps minutes and loses hours.